So we're now live. Welcome everyone to the Committee on Taxation. We'll begin today with introductions and we'll start with Senator Libby.
Morning, everyone. My name's Nate Libby, and I proudly represent all of the people of Lewiston in the Maine Senate.
Excellent. And Senator Pouliot, I don't think is with us. Representative Bickford, we know is not going to be with us. Representative Carmichael.
Morning, I'm Mickey Carmichael. I represent parts of Hancock, Washington, and Penobscot counties, including my hometown of Greenbush.
And Representative Collins is not with us. Representative Gramlich.
Good morning, Senator. My name is Lori Gramlich, and I represent House District 13, which is the lovely seaside community of Old Orchard Beach. I will be in and out today. I have a few competing priorities.
Okay. Representative Hanley. Representative Hanley.
Yeah. Hold on.
Go ahead and introduce yourself.
Good morning. I'm Jeff Hanley. I represent District 87, which is Pittston, Alna, Wiscasset, and Randolph. I will be leaving around 10 o'clock to go to education, but I'll be back.
All right. And Representative Kryzak.
Thank you, Mr. Chair. I'm Ted Kryzak. I serve as House lead on this committee, and I represent Acton, Lebanon, and Shapley, District 20.
And Representative Matlock.
Good morning. I'm Ann Matlack. I represent House District 92, which includes the communities of Cushing, Thomaston, South Thomaston, St. George, Matinicus, Creehaven, and the Muscle Ridge Islands.
Representative Perry will be with us in about a half hour or so. Representative Sachs.
Good morning, everyone. My name is Melanie Sachs. I'm proud to represent House District 48, which is Freeport and part of Pownell. I'm one of those having technical difficulties today. I'm on my phone, so hopefully you can stay here for the meeting, and also will be in and out due to priorities. Thank you.
All right. And Representative Terry.
I'm Mo Terry. I represent District 26, which is the west side of Gorham, and I serve as House Chair. Also having some technical difficulties. I'm at my parents' house.
All right. And I'm Senator Ben Chipman, serve as Senate Chair of the committee, and I represent District 27, which is part of the city of Portland. Also with us this morning is our committee clerk, Avery Page, and our analyst, Julie Jones. And before we get into work sessions on bills this morning, we did have a request from Senator Jackson to take up amendment review of LD 188. So if Senator Jackson's with us, Avery, if you can let him in to the room, or if Max or someone from his office is with us, please let them in as well. They may want to offer additional information about the amendment. I know they put a lot of time into drafting this amendment, and we'll let Julie, I guess, walk us through the amendment on LD 188. And there was some question, Representative Terry, about whether we want to do the amendment review on all 5 of these amendments that are ready today, or just take up this one and then do the other 4 after the work sessions. What do you think?
I'd say that's not a bad idea, seeing that we're all kind of going to be in and out all the time, since the majority of us are here right now. I think that sounds like a good idea.
We'll take up all the amendment reviews, Julie, but we'll start with LD 188 at the request of Senator Jackson, and then we can go to the others.
Okay. Let me
And Avery is
share it with you.
with us, or anybody from his staff? Or?
No.
Okay. Do you mind reaching out to his office just to let them know? He did want to be before it. I think he asked that we take it up first, so you can maybe reach out to him, and we'll have Julie start walking us through the amendment.
Yeah, for some reason, the amendments are not showing up when I'm trying to share them. Okay. I'm going to have to get it another way. I guess it should be showing up the way it looks on my screen, but for some reason it's not. So I'm going to have to go into it another way here.
Sorry, my phone was ringing as well.
Senator Pouliot joined us. If you'd like to.
I'm having internet problems too. I'm in a meeting. Told them not to call me.
So just got a text from Senator Jackson. He said he's fine with the way the amendment's drafted. So I don't know if he'll be able to be joining us or not, but since we're having some technical issues, Julie, should we go into work session on one of these other bills, or should we wait for a few minutes?
Let's wait a minute.
If you could give me a few minutes to try to straighten out what's going on here, because I had it all set up to go before we started. And when I go to, the shared documents are all parked in one location. And when I go to that place, well, I can do 188, let's see. But the other ones are not parked right now. Okay, 188 is up. I've gotten that in by my secondary route. This is, you want me to go ahead with this one now?
Sure, go ahead.
Yeah.
Yes, okay. LD 188 is an act regarding the transportation of products in the forest products industry. President Jackson's bill, sometimes lovingly referred to as the cabotage bill, since usually people who hear that word, including me, fall in love with it for some reason. I don't know why. This is the bill that would provide sanctions for property owners who have land and tree growth, who, when they harvest the wood from that land, it ends up being transported from one location in the state to another location in the state by a driver who is not a United States person. And federal law, the federal cabotage law prohibits that type of transportation by persons who are not US persons from one location within the country to another location, from one location within the United States to another location within the United States. This amendment sets up a process for, well, the original bill would provide that someone who violated, a landowner who had wood products transported in violation of the cabotage laws would be removed from the tree growth tax program and would have other tax incentives not available to them. There was some difficulty in terms of how that would be enforced, given that the law that's in question, the cabotage law, is a federal law, and state officials are not in a position where they have at least done a lot, I guess, from what I've heard, to enforce that law. This amendment would set up a state civil violation for transporting wood products from one location in the state of Maine to another location in the state of Maine in violation of federal law or regulation or international trade agreement. Part of the issue may be that the restrictions are not actually something that's in a federal statute. They may be something that's pursuant to an international trade agreement. So this sets up a state civil violation for violating the federal law, the landowner who has their wood products transported in violation of the cabotage law. So there would be a $50 fine for the first fee, for the first violation, $1,000 fine for the second violation, and $1,500 for the third and any subsequent violation. And the forestry division, state forestry division, would have responsibility for enforcing the law. If the landowner is found to have violated the law 3 or more times, then the penalty would be that their property would be suspended from the tree growth tax law for 2 years. And during those 2 years, the land would have to be assessed at its just value rather than its reduced tree growth value. The landowner would also be not eligible for the Betty property tax exemption, the better property tax exemption, the Betty reimbursement. No, it's the other way around. The Betty exemption. Sorry, I've got 25 bills that are floating around in my brain, so my brain is not functioning as efficiently as I would hope it would. The Betty exemption, it's an E, so it's an exemption, or the Better program, or an income tax credit that is applicable to taxable income resulting from the landowner's business activities. So it would have to be a tax credit that they're receiving pursuant to their business activities. The Division of Forestry would have to notify the state tax assessor of any, and municipalities, because they administer tree growth, of any violations of the civil violation provision. And there is a fiscal note. Why? There should be an appropriation in that amendment. Somehow I've got the wrong version of it. But the fiscal note, let's get down to the amendment would contain an appropriations for 3 additional positions for the Department of Agriculture, Conservation and Forestry, for 3 forest ranger positions and associated costs. They need cars and a variety of equipment. And there would be 1 for each region in the state. They apparently have 3 regions, so they feel that they would need 1 for each region. That is reflected in the fiscal note, is the appropriations that have been requested. It's not showing up on this version of the amendment that I've tagged here to show you, but the amendment itself does have an appropriation in that amount of money in it.
Okay, so Julie, the Rangers would, the new Rangers would be charged in each area where they're working to go after this kind of stuff and enforce the new law?
Yes, and provide training to other persons within the department who may be running into these situations. I mean, it wouldn't just be those 3 people who would be enforcing it, but they would be in charge of the enforcement of it within their region. So other forestry department employees might also note a situation like this and be involved in some of the enforcement activities, but these 3 people would be in charge.
Looks like a decent amendment. Representative Krajicek, you have your hand up?
I do. Thank you, Mr. Chair. I voted against this when we had our work session, and I'm going to vote against it again. My issue is anything to do with the tree growth. It is an amazing program, and it works so well. I don't know why we haven't had anybody from the Department of Labor, because from my research, the Department of Labor has already looked into this, and it is not a problem. Also, I found out through a friend of mine who used to work for the DEA and the CIA that all it would take is for either the Sheriff's Department, the Forestry Department, the State Police, any police department that's in any of these areas would just have to be sworn in by the federal government to that department. They wouldn't become a member of that department, whether it be the Border Patrol or DEA or any of those departments. They would just be sworn in, they would become a member, and they could enforce this law, this federal law. I understand he's changed it down to just some fines for the first 3 times. But from what I understand, this is not an issue according to the Department of Labor. And I would like to see the Department of Labor come in and give us some information about the research that, and not the research, but the actual looking into this problem, specifically with the one person who's the senator brought up was doing this. Because the thing is if these folks have a permit from the federal government to work in the United States, then they can drive within the state. If they are only dropping a load off or picking a load off to go to Canada, that's one thing. But I am deathly afraid of attempting to anything with the tree growth. he's saying that if they get caught 3 times, then you're going to take them out of tree growth. Well, the way tree growth works is you would have to pay all the back taxes on all the land that you own in order to come out of tree growth. Now, if somebody that owns 1 million acres that has 20, 30 lakes in their property, suddenly that's going to become property that is going to be taxed at lakefront lots. So if I was the owner of 1 million acres and you told me I couldn't have tree growth anymore, I'd be putting up condominiums and golf courses. And that's what I'm afraid of, is if we start going towards using tree growth as a stick, that we're gonna lose a lot of our forestry land in northern Maine. Now, I understand that the senator has an issue with people from Canada driving in the state. There is a federal law. The federal law can be enforced, and the Department of Labor has already looked into this. So I am dead set against anything to do with going after tree growth. Thank you.
Thank you, Representative Krajicek. Avery, bring Senator Jackson, and I guess he is in the waiting room at this point, and I'd like to get a response from him to some of those comments, since he worked on the amendment and probably knows more about this than anybody.
Yeah, I just promoted him. He's on now.
And so I guess Senator Pouliot, if you'd like, we'll hear from Senator Jackson.
Thank you, thank you, Senator Chipman and members of the Taxation Committee. So I heard Representative Krajicek's conversation, and while I appreciate what he's saying, I disagree. The Department of Labor has not looked into this. Actually, just the opposite. The Department of Labor felt that they didn't have the jurisdiction. That's what started this whole long-term chase on the federal side. I actually had a meeting last week with members of Homeland Security in DC and members of immigration. Come to find out, there's only one other state in the entire United States that uses H-2 workers in the forestry occupation for logging, and it's Missouri, and they have two members that actually work in the H-2 program, and neither one of them are truck drivers. So this issue is unique to the state of Maine, and it is absolutely not accurate that if you're an H-2 worker, by the fact that you've gotten the H-2 application, that you can do cabotage back and forth across from Canada to Maine. That is not the case at all. That's why this law is important, to try and get Maine's law enforcement to be able to do it. I disagree with the department. I know the department doesn't want to do it because, unfortunately, they're influenced by the Maine Forest Products Council. You don't need 3 new people. The department is already out there looking at timber theft, timber violations. I mean, if some of the members would have been able to watch the video that I provided, the trip tickets that were on that video were actually procured by the Maine Forestry Service. That was their inspections already that provided that information. And so the department is already doing these inspections currently. They just don't believe that they have the ability to enforce this federal law whenever they do find these violations. And so this law would actually allow that. And as far as the tree growth, I mean, you can certainly argue that that's too big of a violation. But the reality is landowners know 100% what's going on. They've been able to shed liability by saying, well, it's the independent contractors. I think giving them 3 strikes before you actually have to use this bigger stick is absolutely appropriate. I mean, they can clean this up tomorrow. They can stop this tomorrow if they wanted to, but unfortunately they don't want to. After 3 times, they would definitely have to at this point. And so I actually think what Julie come up with for amendment strikes the right balance. It's not everything that I wanted, but it's definitely a better amendment than we had 2 years ago. And I certainly appreciate the committee looking at it, and I hope that the members that voted for it continue, because again, we are elected to represent the people of the state of Maine, not workers that are coming across taking opportunities from Mainers. So that's why this law is important, and look forward to taking it up this week.
Great. Thank you, Senator Jackson. So just want to, I know some members have their hands up, and just wanted to remind folks, we've already voted on the bill. It's just a language review of the amendment. And unless someone's making a motion to reconsider or take up another vote, we wouldn't be voting again today. We're just asking clarifying questions about the amendment to Julie, if there's any clarifying questions. We just don't want to get into a big floor debate on this if we already have debated and voted on the bill. I see that you still have your hand up, Representative Prazak, and then Senator Pouliot had his hand up as well. Senator Pouliot, do you have something you'd like to ask about?
Yeah, so I got a call after we voted on this bill from one of my constituents, and who I have a lot of state employees who are constituents more than anyone else, and a lot of commissioners that are former commissioners that are constituents. And so Ron Lavaglio, who was the former commissioner of the Department of Corrections under the Baldacci administration, I think he might have started under King, actually, I'm not sure, but anyway, he called me and he was vehemently opposed to this legislation, and I explained to him that I already voted against it, but I just wanted to, let Senator Jackson know. I know he's on here. I've got constituents in my district that are opposed to this legislation. So while I appreciate the effort, I'm going to continue in, my position where we were at on that. Thanks.
Great. Thank you, Senator Pouliot. Do you have any clarifying questions, Representative Prazak, or your hand still up?
I just want to say that I would be more than willing to vote for this bill if the tree growth piece was taken out. There is fines that he's putting in, so it actually becomes a state law, so that if this is an issue, then we can start working on it by fining people. But it frightens me to attempt to go into tree growth at all.
Okay.
Feel the same way.
So it sounds like some members would support it without the tree growth piece and keeping everything else. I maybe we could ask Senator Jackson if that would be amenable, or if we should just stick with what we have. Senator Jackson, do you have any thought on that?
Well, I would ask the members, and obviously Mr. Lavaglio worked for International Paper for years, so I mean I've spoken to him numerous times, but I would ask the members that are offering that, what would be the alternative to the landowners? I mean, the landowners drive this whole issue. I mean, they hire the independent contractors, and please don't try and tell me they don't know what's going on, because I mean, they got black boxes and members and truckers' trucks. I mean, they track every minute of a day to these independent contractors. So what would be the alternative to try and convince landowners to do the right thing?
So Senator Jackson, just to be clear, you think we should just stick with this amendment that's here, not reconsider and make any changes to get other members on board, and just stick with what we got?
Well, like I said, unless, in my opinion, unless members have a reluctance on the tree growth, unless they can come up with some alternative to try and get landowners to do the right thing, I don't know why. I mean, like I said, this was an attempt to try and get at the root of it. And so I'm more than happy to consider another, maybe a floor amendment, but I don't know what that is at this point.
Yeah, I was going to suggest maybe it could be worked out with a floor amendment, in the meantime with go ahead, Representative Prazak.
Thank you, Mr. Chair. I think I have an answer. If we do it without the tree growth in there, each time a company is fined, it is turned over to the federal government. So then the federal law comes in, and those folks that are actually doing the driving will lose their ability to be in the United States. So it fixes the issue. You fine the company for doing it. The federal government finds out that this person that's coming from Canada is breaking the law. So the federal government takes away their H-2. So I think it's a win-win, and we don't have to go anywhere near tree growth. And I'd be more than willing to vote for that, and we could have a unanimous coming out of the committee, I believe.
You're suggesting taking the tree growth penalty out and putting in a penalty of a fine to the landowner?
He already has the fines in there.
Okay.
But each time a company is fined, the federal government is notified because they're violating the federal law also. Then the federal government would have to act on it. And they could, if somebody's got an H2 filing, then they could actually pull the H2 filing and they would not be allowed into the country anymore. It's what I was talking about earlier. If we deputize some of these police officers, either the Rangers or the state police or the sheriff's department, then they could enact the federal law. But if we put this into effect, that each time that the company is fined, that the federal government is notified, then the federal government would have to act on this, and those folks would not be allowed in the country anymore.
Yeah. Well, why don't we leave that up to, you Representative Krajzak and Senator Jackson and others to talk about. I mean, Senator Jackson suggested there could be a floor amendment to make some changes, but just let people, think about that suggestion and any other ideas they have, and, let the amendment go as it is so the bill can leave the committee and get out to the Senate and House. And if everybody can come together behind some floor amendment to make some change to get more support, great. But, I'm not sure we're ready to do that today or try to work out another amendment this morning. Just give people some time to maybe think about what's been said this morning. Does that seem all right to you, Senator Jackson?
Yeah, actually, I have Representative Krajzak's phone number. I can give him a call later. Certainly would try to accommodate, and we can have that conversation. I don't know that Representative Krajzak can bring everybody along, but I'm more than happy to try and work something out with him.
Okay. So if everybody's okay, we'll conclude the amendment review on LD 188 this morning, and we'll now let Julie proceed with amendment review on the other 4 bills we have amendment review for, and then we'll get into our work sessions.
Am I understanding correctly on 188 that you're approving the committee amendment to be reported out and any changes will take place with a floor amendment?
Yeah, we're not going to make any changes this morning. I mean, there was some discussion about some potential changes, but we're going to let the different parties work that out in terms of any changes that could be made with the floor amendment if they come to some agreement on that. But we're not going to change the amendment that's drafted here. We'll report that out.
Okay.
All right. Great. So now if we want to move into the amendment review for 179 and 435, 506, and 611. Then we'll start.
Yeah, it's going to take me a minute to pull them up here.
Okay. No, look, take your time. If people having technical issues this morning, but
okay, just going numerically. The next one is 179. Okay, let's hope this one is showing up here. There it is. It's only letting me do one at a time for some reason. Okay, 179 should be up now. This is an act to exclude energy efficiency improvements from property tax. The original bill provided a property tax exemption with regard to certain types of fuel efficiency equipment, which would have had to be certified by Efficiency Maine, I think. And a lot of the testimony seemed to be in the direction of heat pumps being assessed in different ways in different municipalities. The committee amendment instead replaces the bill with a resolve. This is similar to a situation that happened a couple of years ago with regard to solar energy, residential solar energy installations. So this follows that pattern, directs Maine Revenue Services to establish a stakeholder group involving municipal officials and people in the energy efficiency, including heat pump field, to explore the issue and to come up with basically a standard guidelines for how this type of property should be evaluated, which would then be provided to municipalities. It requires the department, meaning Maine Revenue Services, to prepare and submit a report to the Taxation Committee by December 1st. Excuse me. And to provide information to municipalities with regard to guidelines for assessing this type of property.
This is Representative Kessler's bill, if I'm not mistaken. I believe it's the one we talked about with heat pumps being excluded from the property valuations.
Yes.
Yes.
Okay. Excellent. Any concerns about that amendment? Seeing that, okay, we'll go on to 435.
Yeah, again, the fiscal note is supposed to have been attached, and for some reason it's not. I don't know what's happening. Things were fine earlier this morning when I lined them up. But the fiscal note in the bill simply says that the additional costs to Maine Revenue Services can be absorbed within existing resources. That's all it says.
Existing resources. Okay, that's good to know. Great.
Okay, stopping sharing this one. Bringing up hopefully 435. Okay. Share. I'm sorry, it probably looks strange to you. You probably see my face looking down really closely to the screen. For some reason, I'm not getting 435. Are you seeing 435 now?
No, we're moving on the screen, except ourselves.
There it is. Okay, LD 435 is Representative Pickett's bill to provide a sales tax exemption for certain educational collaboratives. As far as we know, there's only one or two of these. These are regional organizations that are set up with members who are school districts. The original bill placed the exemption in the subsection of law which related to government entities. Maine Revenue Services suggested that these are not really government entities. Their members are government entities, but the organizations, the collaboratives themselves, are not government entities, and they suggested putting it in a separate subsection. So that's what this amendment does. It removes the same language to a section at the end of all of the subsections as opposed to being under the government section. It provides an appropriation to Maine Revenue Services, the $5,000 for the costs of setting up the sales tax exemption and computer programming costs within the department. And it is estimated that the revenue loss for that would be about $3,800 going forward. So it's the $5,000 in the first year plus the $3,000. Well, no, it's for the first year. It's not a full year, so it's $5,000 plus $1,900 for partial year exemption, and then ongoing $3,800 estimated revenue loss.
Any concerns from folks about the amendment on LD 435? Not seeing any. So I think we're okay with that, Julie. We'll, on to 506.
Yep. Am I still here?
Yes, you're still here.
Okay, for some reason I've lost my screen sharing.
We see 506,
Yeah,
Julie.
Yeah.
You see 506?
We do.
That's interesting. Okay. I'm not. But okay, you still seeing 506?
Yeah, we can
Yes.
see it. I mean, we just
Okay.
see the top part of it. You're scrolling down through it
Yep,
now.
scrolling down. This bill is an act to reduce the tax burden on low-income electricity customers. It is Representative Barry's bill. Provides a sales tax exemption for individuals who are low income, participating in the low income assistance program or part of an arrearage management program. So they would have to be people who are already identified as being in difficulty in paying their electricity bills. The only thing this amendment does is to provide an effective date. The bill itself did not have an effective date, and we put one in for sales tax exemptions. And the one we've been using as a standard date this year is January 1st, 2022. So it would add that effective date and a fiscal note, which okay, is not showing any positions, but it's showing a revenue loss of $68,000 in the first year, which would be the half of a fiscal year. It starts in January, and about $137,750 in each additional year, not additional, subsequent year.
Concerns about the amendment on LD 506? Seeing none, we can move on to the last bill for amendment review, LD 611.
Oh, my screen is back. 611. I've got 611. Share. Oh, I had 611. There it is. Are you seeing 611?
Nope, we're not.
Yeah.
Are you seeing 611 now by any chance?
How
about now?
Here we are. Yeah.
You got it? Okay. I'm sorry. I don't know why this is not working. LD 611 is an act to exempt long-term lodging from the 9% sales tax. This is Representative Rudnicki's bill. At the public hearing, she presented a proposed amendment to the bill to change the language in terms of who the bill would refer to. It relates to the sales tax on lodging, and specifically with regard to trailer camps. Under current law, a person who resides for 28 days or more is exempt from sales tax. This bill would provide that an individual would have to reside, that an individual, well, no, talking too fast. Current law provides that the exemption applies to a person who resides continuously for 28 days or more if the individual does not maintain a primary residence at some other location or is residing away from their primary residence in connection with employment or education. And under current law, if the person rents living quarters for 28 days or more consecutive days in connection with their employment, if they're required to do so for purposes of employment, then it's exempt. What this bill proposes to do is to add in an extra category of people who are residing in one location, in this instance, a trailer camp, for 90 days or more. They would also be entitled to an exemption. They would not have to meet the requirement of not having a primary residence someplace else or residing in the trailer camp because it has something to do with their employment. It would also, the bill itself had an effective date, but its effective date was January 1st, 2021. This would change it to 2022. I'm not sure whether it was intended to be retroactive or how it ended up being 21 in the original bill, but as a practical matter, this would make it applicable beginning next January. Fiscal note. It's estimated that the revenue impact would be $57,000 in FY 21-22. They're probably not being, well, primary rentals would be during the summer season primarily. So the first year being a half fiscal year up through June 30th, the impact revenue loss would be $57,000. After that, about $329, $22 through $28,000 revenue impact anticipated to be lost from the sales tax exemption for a full year.
Any questions or concerns about the amendment for LD 611? None, I guess everybody's okay with that. So that concludes our amendment review for this morning. So I guess we should go right into work session on LD 527. This is an act to exempt main care Appendix C private non-medical institutions from the service provider tax. And if Senator Vitelli's with us, Avery, if you could let her in, that would be great.
Should I start?
Yeah, go ahead, Julie.
You said Senator Vitelli?
Yeah, Senator Vitelli is the sponsor of this bill. If she's not with us, that's fine.
Yeah, because I'm not seeing her.
I just wanted to give the sponsors, as we go through the work sessions, the opportunity to offer additional information if they have any to offer. But if she's not with us, that's fine. If she does come into the room at some point, feel free to bring her in.
I'll keep an eye out.
Thank you. Yeah, go ahead, Julie.
LD 527 is Senator Vitelli's bill and act to exempt main care Appendix C private non-medical institutions from the service provider tax. This bill is quite similar to a bill that was introduced 2 years ago in 2019. At that point, the legislature turned the bill into a resolve and directed the Department of Health and Human Services and Maine Revenue Services to examine and evaluate the tax, including as it applied to PNMIs, and to include in their review alternatives to the tax, the service provider tax on PNMIs, and report to the second regular session. The two agencies did the report and did submit a report last year. As it is, I think it has been emailed to you, I think, and has been is included on the tax materials list under LD 527, both the resolve from 2 years ago and the report back from Maine Revenue Services and DHHS. In its testimony, the DHHS indicated that although the summary of the bill says that it refers to Appendix C, it has a generic description because we're talking about a document which is not part of actual law. It's a Department of Health and Human Services internal document relating to their administration of the main care program. But the department indicated that the description might also apply to Appendix F, private non-medical institutions, and did not know whether that intent was needed to be cleared up one way or the other. The other thing, and I believe that we have people here from the Department of Health and Human Services, be either Michelle Probert or Molly Bogart, who can talk to this more than I can, but it is my understanding that, well, the use of revenues from these types of organizations, the revenues go to a dedicated account, which is used to match federal Medicaid money and draw down more federal money. There are federal requirements on what types of revenue can be used for that purpose. And it is my understanding 2 years ago that the federal government had started to question Maine's use of the service, or at least portions of the service provider tax for matching federal Medicaid funds. The last I knew, that issue had not been resolved, but if somebody is here, Ms. Probert is here, I notice, can talk to you about that with much more knowledge than I have about it.
If we want to hear from her now.
I'm happy to speak. Good morning, everyone. Thank you, Julie. Thank you, Senator Chipman and Representative Terry and members of the committee. My name is Michelle Probert. I am Director for the Main Care Program under the Department of Health and Human Services. I thought it may be helpful if I gave a little bit more of a brief history of the interactions between the Department of Health and Human Services and the Centers for Medicare and Medicaid Services regarding the service provider tax. Would that be appropriate?
Sure, that'd be great.
Great. So I will go back to September of 2018 first. That is when CMS, the Centers for Medicare and Medicaid Services, first sent the Department of Health and Human Services a letter stating that our service provider tax, from their interpretation, was impermissible. In February 2019, DHHS sent a response to CMS in collaboration with the Office of the Attorney General, stating our legal defense for why we felt the service provider tax was indeed permissible. I will note that we have never actually received a formal response from CMS to our arguments for permissibility of the tax since that time. There have been a number of conversations with CMS, but there hasn't been an actual response to our legal arguments. In June of 2019, as Julie noted, this committee determined to turn a former bill into a resolve to look at, I would say, the pros and cons of the service provider tax, as well as potential alternatives. And that resolve was to result in the March 2020 report that was issued a little over a year ago. In October of 2019, CMS sent a letter to the Department of Health and Human Services letting us know that if the state did not replace the service provider tax by the end of the, at that time, current legislative session, that they may issue us a deferral, they call it, of the federal match associated with MaineCare's reimbursement of the tax to providers. In November of 2020, the CMS proposed the Medicaid Fiscal Accountability Act. And this proposed rule, I should call it a rule, excuse me. So MFAR stands for the Medicaid Fiscal Accountability Rule. That was proposed in November 2020. And it included language that would significantly alter the test of permissibility for taxes like our service provider tax. and really would put the CMS rules in point the CMS rules in a new direction in terms of what taxes are permissible and what taxes were not. Because of that proposed rule, which really threw the country from a Medicaid perspective into disarray, national governors associations, hospital associations all responded to CMS with great concern regarding MFAR, because it really kind of turned Medicaid financing on its head. So in that context, the resolve that was due in March of 2020 ended up basically saying that we could not assess the merits or alternatives to the service provider tax, given that the foundation of what makes a tax permissible was potentially being turned on its head, but it had not been resolved at that point because the rule was still proposed. In December of 2020, on December 28th, CMS did issue the Department of Health and Human Services a deferral. The deferral was in the amount of $4.2 million, and that represented the federal match portion, assuming that tax is then spent on Medicaid services. And that $4.2 million was associated with the first quarter of state fiscal year 21. In January of 2020, the Medicaid fiscal accountability rule was officially withdrawn. And since that time, we actually just yesterday officially responded to CMS with our arguments for why we feel the grounds of their deferral are incorrect and that the tax is indeed permissible. I will also note that earlier this month, on April 6th, CMS issued us a second deferral in the amount of $4.1 million for Q2 of state fiscal year 21, also associated with the service provider tax. And that brings us current with what has been happening with the service provider tax between Health and Human Services and CMS.
Any questions from members of the committee? Seeing none, appreciate the overview and the explanation, Ms. Probert. Thank you so much. So we're now in work session on LD 527. Any committee discussion? Anybody like to make a motion on the bill? Senator Pouliot.
Thank you, Mr. Chair. This has been an issue, I think, for quite some time, and I recognize that there has been a desire to try to pull down some matching funds, in the past with this fee on there. But I think the time has come for us to make this change, and for that reason, I would be supporting this bill with a not to pass motion.
Second.
You're making motion, Senator Pouliot?
Yes.
Okay, motion made by Senator Pouliot ought to pass, I assume as amended with a fiscal note.
Correct.
Seconded by Representative Terry. Any additional committee discussion? You have your hand up, Ms. Probert. Do you have something additional you want to add?
I did. There were just other questions that I had received that I was prepared to respond to if you want me to at this time.
You want to point additional questions, answer additional questions, Representative Terry?
No.
Okay. I guess we're all set, Ms. Probert. Thanks for being with us. So we have a motion ought to pass as amended. Any further committee discussion? Seeing none, all those in favor of the motions, please signify by raising your hand. It appears to be unanimous of all those present. So we'll now close the work session on LD 527, and we'll go into work session on LD 846, an act to promote benefit corporations. sponsored by Representative Morales. And if Representative Morales is with us, if you want to let her in, Avery. Not sure if she is or not, but so Julie, take it away.
Okay. Yes. LD 846, as you mentioned, is Representative Morales' bill. It's a concept draft as it's presented. Representative Morales at the public hearing, as part of her testimony, which I may be able to share if that's working, proposed changing the bill into a resolve directing the Secretary of State and the Department of Economic and Community Development to work together to develop educational materials and services related to benefit corporations. Benefit corporations is a special category of corporations that was created a few years ago for corporations that wanted to incorporate in a way that demonstrated public benefit, either in terms of the relationship that they had with their employees or the relationship they had with their communities, in a way that demonstrated as part of their purpose an obligation to engage in public benefit activities in addition to looking out for their shareholders. So they're private corporations with shareholders. They're not nonprofit corporations, which are prohibited from making a profit, but they are corporations that have an additional obligation to provide certain public benefits under the portion of the law that permits their organization. I will bring it up in just a second, but I can't talk and try to do it at the same time. The proposed amendment, the language will need some work in order to be an actual resolve. So it shows Representative Morales's intent, and she can talk to you about that too better than I can. But in terms of the types of language that would be in a resolve, it would need to be officially directing agencies to do something. And it sort of implies that, but it's not quite as direct. It might need to be. So it will need a little bit of work in order to get the language kosher with the revisor's office and still reflect the sponsor's intent or the committee's intent, or the combination of the two. I will try to share that now.
Great to see the sponsors with us, Representative Morales. Do you have any additional information you'd like to offer the committee, Representative Morales?
Hello, everyone. Can you hear me?
Yes.
Great. I got to be off camera on this, if that's okay.
Sure, go ahead.
Yeah, I think on the bill and on the language, we worked, and I believe Emily Cook is here from the Secretary of State's office, but we worked on some language in the resolve to talk about how the language would just allow for the Secretary of State's office to be more clear about how you become a benefit corporation. Typical, similar to how they would do that for an LLC or any other kind of corporate formation. So I think we have the language, and then Emily Cook should be here to be able to present that language as well. So if she's in the room, I would ask that she be able to speak.
Yeah, one thing I just wanted to mention to you, since the tax part of it is no longer part of the bill, there was, I think, some interest maybe in the committee referring the bill to the IDEA committee, since it's not really a tax bill anymore. And I don't know what your thoughts are about that.
At this point in the session, I think I would hope that wouldn't happen, to not have to go through the process again. And I think if we have all the stakeholders ready to go on this, and you've heard the bill, I would argue for keeping it here and moving it forward here. But I would defer to the committee on your opinion on that.
Okay. Any committee discussion? Or did you have more for us, Julie, that you wanted to go over first?
No,
Okay, you don't, okay, committee discussion, Senator Pouliot.
Sorry, my hand was up from last vote.
Okay. Any others for committee discussion?
I just want to ask Julie if without the tax piece of this, if this is going to be okay for us to get out of committee.
Well, I'm not sure I know the answer to that question. I'm not sure I understand the question when you're talking about getting it out of committee.
Well, is it
The language would no longer have anything to do with taxation.
right? So is there a jurisdictional issue with it being in the committee still and us voting on it if it has nothing to do with taxation? I guess is what we're wondering. I mean, is it the proper format for us to send it to IDEA, or can we just take it up and vote on it when it has nothing to do with taxation anymore?
I'm not aware of any, and the bill's been referred to you. I'm not aware of any. I don't know the answer to that question. I guess maybe you might need to ask your presiding officers that question, because I don't recall ever coming across a situation like this before.
Yeah, I'm not really clear either. So
I don't know how to answer that question.
Yeah.
You have the bill, you can vote on it and report it out, whether, we'll go to the House first, right? Whether, once it hits the House or the Senate, if somebody raised a question about it. I mean, someone would have to question whether it was properly before a body. It's been referred to you, so you've got it, but I don't think there's anything that requires you to send it someplace else.
Yeah.
But I don't know really.
It seems like
what
an
the
idea at
implications
this
are.
point, but I do respect the sponsors' interest in us taking it up today, but go ahead, Representative Gramlich.
Thank you, Mr. Chair. Just for frame of reference, I had a bill that was presented and had a public hearing and subsequent work session in the Judiciary Committee. And it was referred to that committee because a certain section of the statute was referenced, but the bill was amended where it wouldn't have necessarily fallen under that committee of jurisdiction. However, that committee still did work the bill and still voted the bill out. So that helps in the decision-making process. I just wanted to lend that to the conversation that I had a very similar experience in the bill stayed where it had initially been referred, even though some of the language change might have indicated it going somewhere else.
Yeah, I mean, it seems to me that we probably, can still take it up. I guess, if folks still want to take it up, we can, or if some folks want to send it to IDEA, we could do that. So I don't know what other people think. Representative Terry.
Then I would like to make a motion ought to pass as amended.
Second.
We have a motion by Representative Terry ought to pass as amended, seconded by Representative Gramlich. Any further committee discussion? Did we want to hear from Emily Cook, or are we all set? Is she with us?
I'm all set. I think we got a fair amount of information from the Secretary of State when she spoke to us earlier. I think she made it clear what their intentions were.
Okay. I just wanted to offer her the opportunity if she made the effort to be here, but if everybody's okay, we'll go ahead and vote, and all those in favor. It looks like it's unanimous of all those present.
Yeah, just to make sure I have everyone, Senator Chipman, Senator Pouliot, Representative Terry, Representative Gramlich, Representative Matlack, Representative Kryzak, and Representative Carmichael. Okay.
And that was an ought to pass as amended, correct?
Yep, that's what I have.
Very great. All right, so we'll close the work session on LD 846, and we will go into work session on LD 1067. This is sponsored by Senator Baldacci to institute a state amnesty program, similar to something that was done several years ago, I guess. We'll let Julie walk us through the analysis on this bill.
Yeah, I was hoping to catch you before you've totally finished with the previous bill.
Oh.
where the language is going to need some work, like subjects and verbs, primarily. If you could maybe designate a member or two from the committee to work with me on that. I mean, I can send them back and forth between Representative Morales and Ms. Cook from the Secretary of State's office. There's also language relating to DECD. I don't know whether they want to be involved as well, but just if there could be somebody from the committee that would be my focal point.
Yeah, I'm happy to do that, Julie.
Yeah, I was going to
Okay,
say, we
thank
want to
you.
work with the sponsor, Dr. Morales and Emily Cook and UCD, and come up with something, work with Representative Terry, and, you know, that would be fine, and we can look at it during language review.
Okay.
Everything all worked out that needs to be done on that. Yeah, go ahead. That sounds good. All right. So we're now going to work session LD 1067.
Yes, this is Senator Baldacci's bill, as you mentioned, to provide an amnesty program for the state collection of taxes. It would apply, it would designate a period between October 1st of this year and December 31st of this year, so October to 3 months, where a person who is delinquent in paying, who has been delinquent in paying taxes, could come forward and pay the taxes during that time period without being assessed any penalties or incurring any civil or criminal liability. There have been amnesty programs in the past, generally adopted in times where there was an identified need for revenue to be accumulated quickly. And it was felt that by providing an incentive to delinquent taxpayers to come forward, that would instigate the collection of taxes that might not otherwise be able to be collected. I guess that's all I have to say about it.
Okay. Any discussion? We see Senator Baldacci's with us. Senator Baldacci, welcome. Is there any additional information you'd like to provide to the committee?
Well, thank you, Mr. Chairman and committee members. I appreciate it. There's two issues I wanted to respond to in the written testimony from the state. One, in the state's written testimony, they indicate that recurring tax amnesty can cause a problem, and I don't disagree with that statement. The issue is that the last time this state did any tax amnesty was almost a decade ago. So I don't think we're going to find ourselves in a problem of recurring tax amnesty program, since we're close to 10 years from the last time it was used. And then they argue that it may have, and I emphasize the term may in terms of what they've provided, may have harmful effect on tax administration. We've had tax amnesty programs under both two Republican governors, one Democratic governor, and they should, if they're saying that there's some sort of harmful effect on tax administration with that many prior ones over the last 30 plus years, I would think they could identify that. Those are my two responses to that. My third is that when I presented this bill in December, we had a structural deficit, and I don't know what it is now. It's obviously improved significantly, and we're getting federal money. What I would say to the committee is, all of us are on various committees. I'm on Health and Human Services. We're dealing all the time with repairing 10 years of lack of funding in certain areas of human services. There's plenty of areas where $30 million without having to raise taxes could help out situations in terms of healthcare or education. So I understand that these are generally used in bad times, but we're in the middle of a pandemic, so I think it would be welcomed by the public. And I think the general estimate of 30 million is basically how the state brought in extra revenue back in 2002, but I haven't seen an estimate provided yet. I don't know if the committee wants to wait and get an estimate from the tax people as to what they think it might bring in for revenue. That might be helpful, but So those are my responses, and I really appreciate everybody's time and consideration.
Great, thank you, Senator Baldacci. Representative Terry.
Thank you very much, Mr. Chair. Senator Baldacci, are we anticipating $30 million from people that owe back taxes?
We, in 2002, same type of amnesty was initiated, and the state received, identified over $30 to $35 million in additional tax collections. So I'm using past history. I don't have a current estimate. That's why I said that it may be helpful for the state to provide some sort of estimate. But it would, from all prior experiences, bring in money, significant amount of money. So
sure, I would assume, and correct me if I'm wrong, that in 2002, when it brought that kind of money in, they were missing that they were identifying that there was missing money, and MRS is telling us that they're not identifying that there's an issue at the moment.
I don't think it was identified. It was in 2003, and it wasn't.
Okay.
It wasn't instituted because it was identified as an issue with the state tax people. It was instituted because the state needed to raise money, and as I said, we haven't done one in over 10 years, and I think, I'm happy to. I think it's erroneous to suggest that this would not bring in money, and I didn't see that really in their testimony, but I can look through it again. But I didn't see that they said there was no identified collection. I'd be surprised to see that. That means that everybody has paid 100% of their taxes.
Of course.
Yeah, I don't think that's.
I do believe that they did identify that it was not an issue at the moment.
Well, I think that's. Well, I understand, but I just don't agree with that assessment. I think it defies common sense. But I appreciate the committee's time, and I would ask if the committee could carry it over to next year. If the committee doesn't want to act on it, I understand, but I do think it would be a significant source of revenue, and all prior experience with this has produced additional revenue. So, but I appreciate the committee's time. I can sign off unless the committee has other questions they want me to answer.
And that might make sense because right now we're kind of flush in money because of all the federal money that's come in, but next year that money will be gone, or a lot of it will be gone, and we may be in a different situation with the state and we need the money more than we need it now. So it might make sense to carry it over, but
well, I'll let you guys decide, but I appreciate. Oh, I'm sorry.
Yeah, just wanted to ask what do the committee members think about the bill?
I'm so sorry, I don't have a hand raising function on this computer. I'm really sorry. I'm wondering if we can ask Ms. Papadoc to come in and give us a little rundown on what they see as issues with this.
Is Ms. Papadoc with us?
Yeah, I just promoted her.
Thank you.
Welcome, Ms. Papadoc.
Good morning. This is not an area that I work in, so I'm going to have to defer to somebody who has more information for you.
Okay. Is Dr. Allen with us or someone else, maybe from the MRS?
We have Daniel and Mr. Sagasser as well, Mr. Del Sandro, Mr. Sagasser.
Yeah, maybe if one of them wants to come on and just talk about their thoughts about it, how much is owed to the state, what they think might come in from this, that would be helpful. So you can deliberate and decide what to do. Mr. D'Alessandro or Mr. Sagasser?
Yes, I'm turn on my video here.
Welcome, Mr. Sagasser.
Good morning. John Sagasser from Office of Tax Policy at Maine Revenue. Well, you've covered the main points in our testimony and the basic issue with tax amnesties. that they do run against the grain of the tax system, the compulsory self-reporting system. And so having them infrequent is important. There tends to be, so that's one, that they need to be paced. The farther apart, the better. The other is usually in tax amnesties, there is a particular need for short-term money. That's what drives tax amnesties. Otherwise, there's not a real reason. And so, as our testimony notes, it's not clear that there's that need at the moment. And the third is, which you've just been discussing, is usually there's an analysis as to whether it will be effective as far as the outstanding debt and the likelihood of collecting that within different timeframes, rather than it just having the effect of a revenue pull that you would have collected anyway in some window of time. Okay. So those are the reasons why we point out in our testimony, and which you've just been discussing. And that's why we've testified, the administration testified against the bill.
What are your thoughts about, like, in a year from now, if we were to carry the bill over, do you think we'll be in the same situation based on how things look? I mean, I know we're getting a lot of federal money, and that's sort of one-time money that, may be gone or mostly spent by them. I mean, do you think we might be in a situation in a year, the next spring, where we might need something like this to bring in revenue?
Well, I guess I can't answer that because I'm not the one that knows about the way the revenue are flowing looking forward. So I guess you'd want to see what the RFC is meeting today, and they will present a picture. So I guess those numbers will speak for themselves. Right now, at this time, it does not look like there's a need for the revenue. And so that's why the administration is against the bill, given those other concerns. And even if there were a need, there still should be that analysis of, is it likely to bring in revenue that would not be collected otherwise in the reasonable time frame?
I mean, if we were to carry the bill over, do you think there would be time between now and January to come up with an analysis that would be more helpful to us in terms of whether how much money it would bring in, and if it's money that would otherwise come in anyway or not?
Well, it does take some time to do that analysis. And so if the committee was intent on it, then we would need that time to set out those kind of revenue numbers.
I mean, would that between now and say January be enough time to do an analysis like that, or with everything else on your plate? Or
yeah, again, I can't particularly between now and January 2022.
Yeah.
I mean, certainly certainly that's enough time to get information to the state of the revenue flows, the collectibles, the timing of collections, and that kind of information.
Mm-hmm. I mean, I guess I'm kind of feeling like maybe we don't need this right now necessarily, but I see that there could be a need in January or February, and having the analysis could be helpful just to see whether it's money that would come in anyway, or whether this would bring in money that we wouldn't otherwise get. I mean, I don't know how it worked in 2002. I wasn't in the legislature then, but it did seem to bring in $30 or $35 million. I just be interested to know whether that was money that would have come in anyway or not at that time. But you had your hand up, Senator Baldacci. Do you have something additional to that, or?
No, I just wanted to note that I've gone over the testimony, and I didn't see an analysis there of whether there was money out there to collect or not, because I know that had been brought up. But I do agree that having an analysis like that would be helpful in making a decision. And I do think at some point, knowing the history of the state over the last 20 or 30 years, that at some point, or could be, whenever, but it's many points along the way, we will need additional revenue. I mean, even when we're flush with cash now, we're being, things are left unfunded. $30 million in Health and Human Services could fund a pay raise to direct care workers that hasn't been given, that would be matched by $60 million from the feds to 10,000 direct care workers. I mean, there are uses for the money that may be overlooked in other ways or other places, or by the people that we could direct this to. So there are places where this additional money could be helpful. That's all.
Yeah.
Thank you.
I mean, I guess I'm like seeing some real benefit to maybe carrying the bill over just to have some analysis to know how effective it is, if it's money that would come in anyway. At that time, maybe we're more in need of it than some people think we are now, although I guess the case can be made we could use the money now. But it seems to be like maybe some benefit to having more information to make a better decision on it if we were to carry it over versus voting on it today. But I'll just put that out there. What do other folks think on the committee? Any additional thoughts or discussion, Representative Matlock?
At this point, based on the revenues, and as Mr. Sagerser said, the revenue forecasting will be coming out with a report pretty soon, another report pretty soon. The revenues have not tanked the way that it was anticipated a year ago. I think this may be something to hold in our back pocket for another time. I'm not even sure that next year would be that other time, because based on the information we received from DAFS last week about the federal fund that's coming in, half will come in now, half will come in a year. So that we will have revenues over the course of a whole year that can be used for different needs that we do have. And perhaps at a future date, we might be able to take this up again. But at present, and even into next year, I'm not sure I see the need for something like this.
Yeah, I mean, we could, if we carried it over, we'd keep it in our back pocket to next year and could always vote it down if we didn't need it then. I guess I'm just interested in seeing like what happened in 2002 or 2003 and whether that was money that wouldn't have otherwise come in, because regardless of whether we need the money or not, if we can get money that wouldn't otherwise come in, I don't think that's a bad thing. But whether it would have come in anyway or not, if it would have come in anyway, then obviously we wouldn't need this. So I don't know. I just don't feel like I have enough information to make a decision on it. But so I don't know, what should we do with the bill?
Well, Senator, if you feel like we should table it, then I would recommend making a motion to table.
Okay, so are you making a motion to table, or you're recommending someone else make a motion to table?
I think I was recommending you do that. I don't think I have the same feelings, but I'm happy to hold off if that's important to you.
I don't know if I can make a motion to table while I'm chairing the meeting, but I can try, I guess. Yes, I'll make a motion to table. Is there
I'll make a motion. I'll make a motion to table.
Okay, so we have a motion from Representative Gramlich to table, and seconded by Representative Matlock.
Terrific.
Seconded by Representative Matlock. So is there any no further? We can't discuss tabling motions. So all those in favor of tabling, please signify. That appears to be unanimous of all members present.
I just want to say thank you, and I look forward to working with you folks in the future. Thank you.
Yeah, thank you for joining us. Great. So we'll close the work session on LD 1067, and we'll go into work session on LD 1156. This is Representative Arata's bill. There's an employment tax increment financing benefits.
Yes, this bill proposes to make changes to the ETIF program for calendar years beginning in 2022. Currently, under the ETIF program, the amount of reimbursement that an employer can receive for hiring qualified employees is based upon the income tax withholding for those employees. This bill would change that basis, and to, instead of being the income tax withholding, that it would be based upon the gross wages of those employees. And the bill would direct DECD and the state tax assessor, who both administer portions of the ETIF law, to adopt rules to to implement that particular change. At the public hearing, DECD recommended holding any changes in the program until next year. They are currently in the process of an evaluation of both the Pine Tree Zone program and the ETIF program. The two programs are quite closely related because a large portion of Pine Tree Zone benefits are enhanced ETIF benefits. I think that's all I have.
Okay. I think this is the bill that DECD recommended holding any changes until next year. This is the evaluation of the Pine Tree Zone and ETIF that are currently underway. Representative Matlack.
Yes, I understand that DECD would like to hold this bill over. So I am happy to make a motion to table this bill.
Second.
Should we make a motion to carry it over, or just motion to table, and then we'll take it up at the end of our work, I guess, on all the carryover bills? I'm not really clear on that, but yes, there's been a motion.
I would recommend that we hold off on carrying anything over until we see what our whole list looks like, Senator.
Okay.
I think we have a limit of what we can carry over, and I think we're teetering on that at the moment. So it wouldn't be a bad idea to kind of reassess in a week or two.
Yeah, well, that's not a bad idea. So for now, we'll just we'll take up the motion to table the bill that was made by Representative Matlack and seconded by Representative Gramlich. And we can't discuss that. For all those in favor, please signify. So that appears to be unanimous of all members present. All right. Representative Kryzak, are you voting on that? We couldn't hear you. You're voting yes? Voting no? We can't hear you.
Sorry, I'm voting no.
Oh, no. Okay, so that was, I believe, 7 members in favor and all opposed. Please signify. That'd be Representative Kryzak is voting no. Okay. So that motion to table carries. So we'll close the work session on LD 1156. And we will go into work session on LD 1193. This is Representative Brooks' bill to exempt certain disabled veterans from the motor vehicle excise tax.
Yes, that is what this bill does. It proposes to exempt from the motor vehicle excise tax veterans who are permanently disabled and receiving benefits based on 100% service-connected disability. Maine Revenue Services in its testimony recommended substituting different language for that and using language which is currently used in the property tax exemption for veterans. And have the chart up here right this moment, but the language in the chart is in the chart, and from the statute would say veterans who are disabled by injury or disease incurred or aggravated during active military service in the line of duty and are receiving any form of pension or compensation from the United States government for total service-connected disability. Again, that's in the property tax law. So it's something that municipalities would have experience in administering and would be clearer to them potentially than saying receiving benefits based on 100% service-connected disability, which might be harder to determine.
Okay, committee discussion on LD 1193. Representative Terry.
I'd like to make a motion ought to pass as amended using the suggested language from MRS to mimic that of the property tax exemption.
Second.
Okay, so the motion made by Representative Terry, seconded by Representative Gramlich. Committee discussion. The motion is ought to pass as amended. All those in favor? Representative Bickford, you're voting? There we go. So that appears to
I just
be-
have one question, Mr. Chair.
Well, go ahead.
How are we reimbursing municipalities with this?
I think
I
it's
didn't hear-
sorry, Bruce, I think it's the same as the property tax.
Okay, thank you.
No.
Yep.
Is that part of the amended?
No, is that not right, Julie?
No.
No, there is no reimbursement required for motor vehicle excise tax. The state does not
Okay.
reimburse municipalities for motor vehicle excise tax exemptions. The constitutional provision only applies to property tax.
Okay, so
Okay, I'm not gonna vote in favor if we're not reimbursing municipalities.
okay, so does that change anybody else's vote? We're all on the, everybody voting in favor, and then Representative Bickford voting on opposition?
I'm in opposition also.
So Kryzak's in opposition. Okay.
Me as well.
Ted, you want to lower your hand?
Yeah, why don't we have another vote on that? Because we were kind of discussing it as we were voting. So now
Sorry.
now it's been clarified that the municipalities won't necessarily be reimbursed because it's not required in the Constitution to reimburse for excise tax exemption, only property tax exemptions. We have a motion on the table, vote to pass as amended. All those in favor, please signify. Do we have everything, Avery?
Yeah, so for those in favor, I have Senator Chipman, Representative Terry, Representative Gramlich, Representative Matlack.
Okay, all those opposed? Please signify. Representative Perry, you got your hand still up. You're in opposition?
Well,
Yeah, I
Actually-
didn't get him for the first one.
Okay.
actually, I wanted to have a little more discussion on this, because I'm curious if we want to just vote the way it is and have a divided report or talk about reimbursement. So I'm kind of torn which way I want to vote at the moment without further discussion now that that came to light.
What should we do, Representative Terry? This is our second time voting.
Well, I will give you my thoughts on it, and we can certainly keep the discussion going if we'd like. I mean, if we haven't finished counting the vote, I guess we could consider it not, part of, I don't know. I don't know what to do.
Let's everybody lower their hands. Let's ask if there's any further discussion. We have a motion on the table, vote to pass as amended, using the language from MRS. Is there any further discussion from members of the committee?
If we can add an amendment to reimburse municipalities 100% of the tax loss with this, then I will vote in favor if that's part of the amendment.
I would say that I'm amenable to that amendment, to add that to the, to it. I mean, I can't imagine it would be an enormous financial burden on the state to help with that.
But it will add a fiscal note to the bill and will make it more difficult when it becomes law. So
it will.
Keep in mind, as we discuss this, Senator Pouliot.
Well, I mean, if we're not going to pay for it, the other option would, I would think, is maybe make it optional to the municipality. I think we ought to either give them the option or fund it, is where I think I'm coming from. I find myself agreeing with Bruce Bickford.
Good job, Joe.
Somebody record that.
Do you have something, Representative Carmichael?
No, I'm sorry. I agree with Joe and Bruce, so I'd like to see some kind of reimbursement or optional.
Reimbursement or optional? I guess that's a question. So are folks more in favor of the bill with reimbursement, knowing it's less likely to become law and get off the appropriations table, or more in favor of making it optional to the municipalities, where if they choose to do it, they'd lose the revenue, but it wouldn't be a cost to the state and it wouldn't be going to the appropriations table?
I think I'm comfortable with optional.
Optional. Is everyone else okay with optional? Or should we have it be a reimbursement from the state. So no matter what municipality they live in, they are exempt from the excise tax, but the state would pay and it may not become law. Or maybe it would if the fiscal note is small. I don't really know what the fiscal note would be, but.
Can I ask Representative Bickford if he's comfortable with that?
I am.
Yeah.
Do you want to make it optional, Bruce?
That would be all right. I'm not sure if any municipality would do it if it was optional, but
Well, I think I didn't have that in there to begin with, or well, actually, I'm comfortable with it not being there because generally speaking, I don't think it would be a huge financial burden for either the state or the municipality. I don't know how many 100% disabled veterans there are in each particular town, but I would imagine it's not an enormous amount. I don't have the red book in front of me to see what the property tax fiscal impact is. That could give us an idea, but I think that, having it be an option, if there's 10 folks in a single municipality that qualify for that, then that's probably something that a town can handle.
It just seems a little bit odd that, depending on what town they live in, they're going to get this or not. I don't know. It just seems kind of strange to me that it would be different town to town, city to city, but.
unless you have 10 in the town and they all go out and buy $70,000 pickup trucks.
Right.
That would be $100,000 note to the town.
And generally
Or
speaking,
more.
if a person is 100% disabled, they're likely not purchasing $70,000 trucks. It's possible for sure.
My brother's 100% disabled and he does very, very well.
He does. Okay.
Yes.
We just had this debate about excise tax on another bill, and one of the arguments that struck me was like whether you buy, a certain vehicle in Kittery or Fort Kent, like the excise tax is going to be the same. No one's going to be treated different on that. And
Right.
I respect the idea of providing the exemption to veterans, but having it be different from town to town based on whether they choose to do it just seems kind of goes against that argument on the other bill that we had. So I don't know, kind of.
I'd rather see the reimbursement personally.
Yeah.
I mean, we could do the reimbursement and then see what the fiscal note comes back as
right.
from the language review, and then we could decide from there. If it's a small fiscal note, we could say, okay, let's take our chances and send it to a vote and hope it gets funded. If it's a large fiscal note, we could decide to do it, make it optional or something. Right? So
okay,
that seemed to make sense. Maybe just go with the reimbursement for now, and then we can make sure we do the language review on the fiscal note.
Yes, that would be good.
Okay.
Like to make that motion.
Yeah, I'll withdraw my motion and let Joe make a motion.
Okay, go ahead, Representative Perry.
Unless you'd like to make it, Madam Chair, but I'd move ought to pass as we just discussed as the amendment.
So ought to pass as amended using the language suggested by MRS and also providing reimbursement to the municipalities from the state for the loss of revenue for this.
And then we'll review the fiscal note and finalize it then. Yes.
Okay. Is there a second?
Sure, I'll second.
Motion made by Representative Perry, seconded by Representative Terry. Any further discussion? Everybody understand what we're voting on? So we will now take a vote. All those in favor?
I just want to make sure that Julie is comfortable with the language as we've jumbled it around a bit.
Yes. If you do end up in a local options situation, we know we cannot have local options with regard to property tax. Whether we could have local options with regard to a motor vehicle excise tax exemption, I might want to think about a little bit longer and consult with some other people perhaps who.
This vote isn't with an option, Julie.
No, I know that. I just wanted to mention that since I had the floor for a few seconds.
Well, Julie, if you could maybe look into that between now and the time we get the fiscal note, if you have time to ask somebody, and then if we get a large fiscal note and we decide we want to try to do an option to have it not die on the table, then you could shed some light on whether you think we can do that.
Sure.
So that appears to be unanimous of all members present. So we'll now close the work session on LD 1193. And we'll go right into work session on LD 1203. This is Representative Fay's bill to amend the application of the excise tax on non-commercial watercraft temporarily in the state. I'll let Julie review this bill for us.
Yes. Starting off with current law, there is an exemption from the watercraft excise tax for commercial watercraft without an established base of operations in the state, and all other watercraft that are not present in the state for more than 75 days. So if they're here for fewer than 75 days, it always seems like an awkward sentence construction to me, but if they're here fewer than 75 days during the year, they are not required to pay an excise tax. This bill would reduce the 75 days to 28 days to shorten the period that the period that would trigger the exemption. So if they were here for 28 days or less, they would be exempt, but if they were here for more than that period of time, they would be subject to tax.
Okay. Committee discussion on this bill.
I have a question. Julie, go
ahead, Rep.
Sorry, Julie, folks are required to register their boat yearly, correct?
I believe so, but I don't do boat registration, only taxes. So I can't tell you 100% for sure. I bet some committee members have boats or have had boats and could be able to answer that question better than I.
Could you ask the question again?
Go ahead, Representative Pouliot, Senator Pouliot.
Bruce is on a boat right now. He could probably tell us.
I register mine every year.
Go ahead, Representative Bick.
Yeah, they do have to be registered every year, and it's not a very big expense. For example, I've got a 21-foot boat, and the excise tax is like $75.
Yeah.
I mean, it's not a huge amount.
Okay, Representative Perry.
So I thought the trade association with mostly talking about coastal situations, I thought made some sense. I view someone owning a camp on a lake and only using it 75 days and the boat going unregistered completely. But this is in the state, less than 75 days, and the boat has to be registered somewhere. I was picturing a situation where, because they use it less than 75 days a year, they're not ever registering it again. So as long as it's 75 days in the state, something that's not left here year round, and it is being registered somewhere, I think maybe this bill is, I understand the frustration of the town clerk who wanted it brought forward, but I think maybe it's something we don't need. And if people are done discussing it, I'd actually make that motion, but I can also hold off.
Well, you can make the motion and we can still discuss it as long as it's not a tabling motion.
Yeah, I would move on not to pass.
Okay, so we have a motion not to pass by Representative Perry. Is there a second?
Second.
Seconded by Representative Bickford. Further committee discussion, Representative Krasik.
Yeah, it's just a question. This is about they don't pay the excise tax, but they still have to register, don't they? If you have a boat non-registered that's in any body of water in Maine, the game wardens or the patrol will come after you. So this is just allowing them not to pay excise tax. Is that correct?
No, yes. It's an additional registration fee. Other than where their domicile is or where they've registered it yearly.
Oh, I see. So if somebody has a boat that's registered in another state and brings it into Maine, then
correct,
they get 70-something days, but now they're changing it to 29. So this just affects out-of-staters. It doesn't affect residents of Maine.
Yeah. So if they have a boat registered in Massachusetts and they bring it to Maine, right now they can use it here for 74 days and not register it. But if they use it 75 days or more, they got to register it, and this would reduce the 75 days to 28 days.
Thank you.
I need to clarify that this is excise tax, which is different from registration. Registration is entirely different law. I don't know if there's any 75-day requirement for registration. I would have to do some research to find out. I know if you've got a boat that's registered in Massachusetts, that we have reciprocity agreements that with some states, that if a boat is registered in the other state, they can use it in Maine, as long as Maine people who have a boat registered in Maine can use it in, if it's Massachusetts. Then there are agreements like that, but they're like with a motor vehicle, there's a complete difference between the excise tax and the registration. You sometimes pay them at the same office or across the desk to the same person, but they're entirely different things. And this bill is only relating to excise tax. It doesn't say anything about registration.
Representative Bickford.
Thank you, Mr. Chair. Yeah, people have to have their boats registered no matter where they come from, but they're not registered in Maine. That's the only thing. So they're already paying. If there's an excise tax in their state, they're paying it in their state. If they have their boat in Maine for 75 days or more, then they have to pay an excise tax in Maine. They still don't have to register it in Maine. They just have to pay an excise tax, I believe. And it's crazy to have them pay excise tax to two different states. I think we stay with the reciprocity that we have. And 28 days is just a little too short for me. And I agree with the motion that was made.
All right, any further discussion from members of the committee? Did you have anything else for us, Julie? You got your hand up.
Oh, sorry, didn't take it down.
All those in favor of the motion, please signify by raising your hand.
The motion is ought not to pass, Mr. Chair?
Ought not to pass, yep. That appears to be unanimous of all members present. You have everything you need, Avery?
Yes.
Okay. So we'll close the work session on LD 1203 and we'll go into work session on our last bill, LD 1216. This is a department bill sponsored by Representative Terry to amend the state tax laws and makes lots of different changes. We'll let Julie go over that for us.
And basically, I'm going to be turning this over to Mr. D'Alessandro from Maine Revenue Services, who is prepared to go through all of these provisions for you, since he is intimately familiar with them. And in recent years, we have come to rely upon Maine Revenue Services to present their lengthy annual bills. The only thing I would do is, I do look them over to make sure that they're not sneaking something by us. So hopefully, if they were trying to do that, I have never caught them trying to do that yet. But I do try to check and make sure. The only thing I do want to do is mention the very first thing that Mr. D'Alessandro is going to talk to you about is the timing of a report with regard to the educational opportunity credit. You are hearing a bunch of bills on the educational opportunity credit this afternoon. So I just wanted to mention to you that you might want to just sort of keep in mind the fact that there is this report legislation as well that you're considering. And I am going to bring up the chart. Maine Revenue Services is also very helpful in preparing a chart, which I'm going to bring up screen share for you as Mr. D'Alessandro goes through the chart.
Okay, welcome, Mr. D'Alessandro.
Hello, Representative Terry and Senator Chipman, members of the Taxation Committee. My name is Daniel D'Alessandro, and I'm an attorney in the Office of Tax Policy at Maine Revenue Services. And I can walk through this chart for you. Section A1 of the Act to amend changes the due date for community colleges, and universities, the Department of Education, and Maine Revenue Services Office of Tax Policy reports on the implementation of the Educational Opportunity Tax Credit. Those reports were due February 1st, 2021 for the colleges and March 1st, 2021 for the Department of Education and the Office of Tax Policy. This bill would change those to February 1st, 2022. So those reports were due earlier this year, but due to staffing issues and the other COVID-19 related needs of the departments over this past year, we were unable to complete them on time. And because of the importance of this credit, we really want to put out a good report on the credit. It's an important credit to the state and to the taxpayers of the state. And so this bill would move it forward 1 year.
Okay.
Section A2 repeals the requirement that the remaining funds in the medical use of marijuana fund be used to fund a tax deduction, and the related staffing in the Bureau of Revenue Services. At the federal level, marijuana businesses are denied most business deductions, but medical marijuana businesses are allowed those deductions at the state level. This wouldn't change the deduction, but it would change the requirement that that deduction be funded out of the medical use of marijuana fund. The amount of money involved just isn't worth the accounting, tracking, and shifting the funds around. Section A3 expands the so-called main insurance premiums retaliatory tax to include insurance companies incorporated in the District of Columbia or possession of the United States. Right now, it just applies to states. Sections A4 through A9 relate to Maine partnership audits, Maine and federal partnership audits. In 2005, there was a significant major federal change to the way partnerships were audited. Before, the federal government, the IRS, would audit partnerships, but then would have to assess the partners individually. And for large partnerships, and this just relates to large or complex partnerships, that was very difficult and really kept the IRS from auditing very many partnerships. And so there was a federal change allowing the IRS to audit the partnership directly and then assess the partnership directly. Now, because state income taxes are linked to the federal income tax, that required states to relink. Before, we would have picked up when the partner was assessed. Now the partnership could be assessed and the state would need to pick up on that. The Multi-State Tax Commission produced model legislation, which states have been enacting. And in the 129th first, Maine enacted similar legislation based on the M2C model legislation, but without some of the elections. And in that legislation, the state can audit the partnership, or the state can take that federal audit of a partnership and assess the related state tax directly to the partnership. What has happened since then is the federal government has released new rules that have raised the question of what happens if the audit actually results in a refund to the partnership. And at the federal level, that refund could go directly to the partnership. In some cases, it might go to the partners. But at the state level, there was a missing link. And so what this legislation does is if there's supposed to be a refund, it allows the state government to send that refund directly to the partnership, similar to if there was a tax, the liability would be assessed directly to the partnership. It also has a technical fix allowing or clarifying that the partnership itself can initiate the process. It doesn't have to be a federal audit. It can be initiated by the partnership itself through an administrative adjustment request. And if it is, then it follows the same process that an audit would. The next one relates to the renewable chemicals credit and the biofuels credit. This was enacted. The renewable chemicals credit was enacted last year. The biofuel credit was reinstated. And these are technical changes that are in line with that enacting, not changing how the goals or the overall credit amount, but making some technical corrections. A10 and A13 modify the report, the DECD report on the credit, to remove the required reporting on the number of indirect jobs created and to require reporting on the newly reinstated biofuels credit, in addition to the report on the renewable chemicals credit. Section A11 makes a few technical changes. First, it adds taxpayer information reporting and third-party testing and verification requirements to be specified by rule. And it clarifies that the renewable chemicals may not be sold as food, feed, or fuel, and that they must be produced in Maine. The intent and the language was for this change was in the initial bill, but the syntax was not as clear as we felt it should be. And so this is tightening up the language of the bill to maintain those requirements. It also clarifies several definitions in the renewable chemicals tax credit, and it defines and specifically includes cellulose nanomaterials in the definition of renewable chemicals. And this is done by the proposed committee amendment, which you should have received at the public hearing. My comments are going to include the proposed amendment as I go through them. And so that. Section 812 establishes a penalty for a person, and generally an employer, who fails to provide information returns to the state tax assessor, or who willfully furnishes false or fraudulent returns. Generally, the returns of information would be Forms W-2 or Forms 1099 or similar forms. The employer is required to provide these forms both to their employee and also to Maine Revenue Services. And there's currently a penalty for failing to provide them to the employee, and this would add the penalty for failing to provide them to Maine Revenue Services.
I have a quick question on that one.
Yes, go ahead, Representative Terry.
Thank you, Mr. Chair. Mr. D'Alessandro, currently, what is the penalty if a form is not sent to an employee?
I believe that's the same penalty. It's the $50 for each failure.
Okay, thank you.
So we've covered A13. A14, there was, when this bill was printed, it contains emergency COVID-19 related provisions that affect tax year 2020. And so there was an emergency clause put on the bill, but because those COVID-19 provisions were enacted as part of the supplemental budget, the emergency clause can come off. And so the proposed committee amendment would remove the emergency clause and the effective dates from these parts. And so A14 would have been set an effective date, but that's no longer necessary. So the committee would remove it. And this final income tax provision provides an individual taxpayer a subtraction modification for amounts previously added back to federal taxable income by a corporation of which the taxpayer is a shareholder. This relates to bonus depreciation and the Maine capital investment credit. What happens is there is an addition modification in year one and then a subtraction modification in future years. And what could happen is the taxpayer could be a taxable corporation in year one when they have an addition modification, but then switch to an S corporation in future years, taxable to the individual shareholder. And without a specific link between the corporate modifications and the individual modifications, they would lose those future subtraction modifications. And this provision provides that link. It existed in law to prior Maine capital investment credit law, but when the Maine capital investment credit was changed, I believe 2 years ago, that link wasn't maintained. And so this would reinstate the link for the new Maine capital investment credit. Part B has to do with sales tax. Section B1 clarifies that the definition of in this state includes sales of tangible personal property and taxable services sourced in this state pursuant to Title 36, Section 1819. Section 1819 explains when a sale is sourced to Maine. And we had when this new sourcing provision was enacted, we had a definition in sales tax law of in this state, which got to the same point and And the sourcing provision is further explaining what in this state means, but the explicit link between those two, the definition and the new section, wasn't made. And so this is a technical change making that link. The next several provisions have to do with sales tax nexus. For people who've been on the committee for a little while, you'll remember that the state had a difficult time imposing sales tax on sales into the state from remote vendors. Those vendors had to have a physical presence in the state in order for Maine to impose a sales tax collection requirement. And there were a number of affiliate and agent-based laws and other attempts by the various states and by Maine to get at these businesses that were selling large volumes into the state but had avoided that physical presence. More recently, there was, Maine had a remote seller legislation, which said if the remote vendor had 200 sales into the state or $100,000 worth of sales into the state, they had to collect that sales tax. And it didn't matter whether they had a physical presence or not. That issue went to the Supreme Court, and the Supreme Court ruled that was constitutional. That wasn't Maine that went to the Supreme Court, that was South Dakota in the Wayfair case. But the Supreme Court ruled that was constitutional, and virtually every state has since enacted similar legislation, every sales tax state. Following that, Maine enacted marketplace legislation, which meant that if there was a company that wasn't selling on its own, but facilitating the sale of other sellers, that marketplace facilitator was responsible for collecting the sales tax. Now that we have the remote seller legislation and the constitutional verification of that legislation in our marketplace legislation, the old sales tax registration and nexus requirements are no longer, some of them are no longer necessary. And what we're doing here is we're cleaning that up. There also has been a national reconsideration of that 200 transaction threshold. And what states and Maine has been finding is that 200 transactions isn't enough for it to make sense for a taxpayer to register in Maine. What's really important is that $100,000 threshold. And so this bill is doing a few things. First is repealing the presumptive sales and use tax registration requirements for affiliate-based and certain agent-based connections with the state. Those are no longer necessary because we have the remote thresholds. It's clarifying a conflict that was created last session. It's clarifying that remote sellers and marketplace registration requirements apply based on sales in the state, not the location from which they are delivered. It's repealing that 200 separate transactions threshold and leaving just the $100,000 threshold. And it's clarifying one of the registration requirements, removing the redundant term storage.
Question, Mr. Chair?
Go ahead, Representative Terry.
Thank you very much. Mr. D'Alessandro, the $100,000 threshold and the 200 separate sales transactions, is that something that other states have sort of followed suit with as well, either or both?
It is. So the South Dakota had legislation that they brought to the Supreme Court, and it had $100,000 in sales or 200 separate transactions. And that was the model most states have used. The ones that moved early, like Maine, had that 200 separate transactions. The one that came later generally have not had it.
Okay.
You can imagine $200, and this is a hypothetical companies like to throw around, but you can imagine 200 books sold into the state. That
Right.
might be $2,000 total. That would have a registration requirement, but there wouldn't be any practical reason that that was a good idea. That
Right.
$100,000 is really what's important.
Excellent, thank you.
Section B4 expands the sales and use tax sourcing provision to apply to all sales and not just retail sales. Section B5 applies this entire part to sales occurring after January 1st, 2022. Section B6 is that effective date that's no longer necessary and being removed by the proposed committee amendment. This last one is being added by the proposed committee amendment, and it clarifies the exclusion from retail sale of pickup trucks and vans with a gross vehicle weight of less than 26,000 pounds when purchased by a person primarily engaged in the business of renting automobiles. When a person primarily engaged in the business of renting automobiles rents these pickups, they have to collect the short-term rental tax. And so when they purchase the vehicles, they don't have to pay use tax on that purchase. They don't have to pay use tax or sales tax when they purchase them. And what this is doing is it's aligning that retail sale exception that exempts the renter from sales tax with the language with the sales tax imposition, so that only those who are subject to the short-term rental tax get the retail sale exclusion. Moving to Part C, the property tax items. Section C1 lowers the declared ratio accuracy threshold from within 20% to within 10% of the state valuation ratio last determined to align with the accuracy requirement provided for state reimbursement for the homestead exemption. Municipalities have to be within a certain percentage of the state valuation ratio, and that percentage is set out in two places. One is 20% and one is 10%. And it's that 10% that has teeth, because if they don't make it, then they lose, the municipalities lose that homestead exemption reimbursement. And so this is just aligning those two numbers to the one that's currently has repercussions. Sections C2 through C6 update and align the audit authority for exemptions that are reimbursed by the state to municipalities, allowing for audit of all the reimbursable exemptions. Now, the committee received written testimony from MMA on one of these provisions, section C6, and MMA was concerned that we were removing the 3-year audit limit for the Betty exemption. Upon further review, we agree with MMA's testimony. We still need section C6, but we would recommend amending the language to preserve that 3-year limit in section C6. In addition, that 3-year limit should be added to section C4.
Since we can't see C4, can you tell us what that is, please?
C4 is creating, section 3.4 would be the general audit authority for reimbursements. So when the municipality has an exemption, the state reimburses them for the exemption, but if the state audits that reimbursement and can say that the municipality has asked for too much or has provided an exemption when they shouldn't have. And so C4 would be the general authority for all of them. C6 is the specific authority for Betty. And so that 3-year limit should be in both of them.
Thank you.
Section C7 is again the emergency effective date that can be removed. Part D is the COVID-19 provisions. Section D1 and D2 align the Title 36 definition of disaster period to align with the Title 10 definition of disaster period. Under Title 36, the disaster would end 60 days after it was declared, but under Title 10, it can go further. And our experience this year was that the Title 36 definition was creating problems, and it should just track the general definition. Section D3 relaxed the work and main requirement of the educational opportunity tax credit during the COVID-19, during tax year 2020 and the COVID-19 emergency. This provision was enacted as part of the supplemental budget, and so the proposed committee amendment removes it here. Section D4 relaxes the primary use requirement of the sales tax exemption for machinery and equipment by determining the equipment's primary use based only on the days in use. This is another COVID-19 related one where we were concerned that businesses were going to be shut down during the emergency, and so we're not going to be able to meet the requirements. Section D5 was also enacted in the supplemental budget. It allows taxpayers to use a sourcing law of another jurisdiction when calculating the credit for income tax paid to another jurisdiction in certain COVID-19 pandemic-related teleworking circumstances. This one was a little complicated, but in short, what happened is Massachusetts and certain other states were going to continue to tax Maine residents that had previously worked in Massachusetts, but now were teleworking in Maine. And Maine was also going to tax those residents. And so we had somebody who was teleworking from Maine in order to comply with health requirements and governor's orders from both states, but we're going to get hit with a higher tax bill, being taxed by both states. And so the supplemental budget addressed this issue by saying Maine would provide a tax credit in that situation, but it only addressed tax year 2020. Since then, since the bill was drafted, Massachusetts extended their policy into tax year 2021, and the emergency has continued. And so the issue is going to continue into 2021. The proposed committee amendment applies that same treatment into tax year 2021. The purpose here is if somebody is teleworking from tax concerns or to comply with government executive orders and other emergency orders, they shouldn't receive a tax penalty. Part E is factor presence. This was an item that I spoke about in the testimony for the bill and was before this committee last year as part of the ACT update. The ACT update received a divided report, but the factor presence proposal was in both reports. And the ACT update eventually died when the legislature adjourned. Part E clarifies and simplifies the corporate income tax law by establishing clearly defined objective nexus thresholds as a practical structure for the current general economic nexus standard. These so-called factor presence thresholds clarify the minimum thresholds that, when exceeded by a corporation, subject the corporation to the main corporate income tax. In addition, the new thresholds create a safe harbor for corporations with little activity within the state that nonetheless have nexus under current law due to a small but greater than de minimis physical presence in the state. The new thresholds are $250,000 of property, $250,000 in payroll, or $500,000 in sales in Maine, or 25% of total property, payroll, or sales determined under Maine's current apportionment law. The thresholds apply to tax years beginning on or after January 1st, 2022. This is another item that's linked with the Supreme Court Wayfair decision. Corporate income tax did not have that same physical presence requirement that sales tax did, and it's long been Maine and many other states' position that economic nexus was sufficient. That's a company's purposeful direction of economic activity into the state. But that economic nexus standard isn't as clear-cut as what we have now in sales tax, where we have a flat dollar amount. And after the Supreme Court approved that approach in sales tax, states have been moving to apply those clear thresholds to corporate income tax. So instead of talking about what somebody's purposely directed connections are with the state, we can look at some clear thresholds, and that's what this bill does. $250,000 of property and payroll, or $500,000 in sales. At the same time, we're able to back away from some of the close calls, or we're able to back away to some degree and allow, say, somebody who has one employee in the state, if they're below that threshold, from the state asserting nexus. Is there a question?
Any questions, members of the committee? Representative Bickford.
Thank you, Mr. Chair. Yes, I have a question now. We have liquor companies that bring their liquor into Maine, and under Maine law, they have to store them in the Maine warehouse. It's not their warehouse. Is that still considered a nexus for them? Or did we correct that when we talked about this, I believe last year or the year before? We had a bill that corrected this, and I'm not sure if that made it all the way through or not.
So that,
Can you clarify that for me?
yes, I can. So that bill also died when the legislature adjourned. There was a question, so there are two related questions. Does the company have nexus with the state? And is the company protected by Public Law 86-272, which is a federal law that limits when a state can assert their income tax on a remote company. And so there was that. Generally, having property in Maine does create income tax nexus. But Public Law 86-272 could protect a company even if that property created nexus. And the bill that you're referring to addressed that concern to one degree or another, but it was not finally acted upon. But in relation to this bill, Senator Sanborn, who proposed the bill you were talking about, raised that 86-272 connection. And she wanted to make sure that this change in Maine state law would not have any impact on Public Law 86-272, and companies would still be protected by it. And that is the case. We proposed an amendment to this bill that would explicitly say that Public Law 86-272 would continue to apply. And that amendment is part of this proposal now.
Perfect. So that means that because they store it in a Maine warehouse and not their own warehouse, it's not necessarily a nexus. Is that correct?
Well, what that means is that if Public Law 86-272 protects that activity, it will continue to protect that activity.
Okay. Thank you.
And this would apply to tax years beginning next year, January 1st, 2022. Part F concerned digital streaming. This was part of the biennial budget proposal, but was removed from that proposal, and is likewise being removed from this proposal through the proposed committee amendment.
So why is this being removed, Mr. Del Sando?
So it was placed in both this bill and in the biennial budget because the timing was uncertain, and we wanted to make sure that it got proper deliberation by the legislature, either in this bill or in the biennial budget, whichever one was appropriate. And it did get deliberated as part of the biennial budget, and the decision was to remove it there. And so this proposal was always supposed to align with that one. And so we're proposing to remove it here as well.
I mean, it was put in, I believe, in a department bill a couple of years ago, and then taken out, and then it was put in the budget and then taken out, and I'm just not sure why it continues to be taken out. I mean, to me, it seems like, regardless of how somebody rents a movie, whether it's they're downloading it through pay-per-view on cable TV or streaming it through Hulu, that they should pay tax on it regardless of how it's delivered to them.
This should be a separate bill, though.
It was in the Act to Update last year, and it wasn't removed from the Act to Update, but it did receive a divided report last year in the Act to Update.
Yeah.
And this was actually the primary, maybe the only contested issue in the Act to Update. It was at least one of them.
But I mean, that is the intent of this, right? Just so that regardless of how somebody rents a movie or a program, that the delivery method would be taxed the same, right?
Yes, that was the intent of this proposal. There are multiple different ways that you can gain access to a movie or audio, and they are taxable in some methods and they're not taxable in others. And this proposal would have aligned those. But the administration is requesting to remove this change from this bill at this time.
Wow. Did they give a reason why they're requesting that to be removed?
So this was something that was actively debated as part of the biennial budget, and the reasons that it was removed there apply equally here. And I think that the administration feels that a change that would increase taxes is not warranted at this time, even though it does align those different mechanisms.
Okay. And I know there's some interest in it just being a separate bill, and that's fine, but maybe someone will introduce a bill for that, because it just seems odd to me that things are taxed differently depending on how you order them. But at any rate, I guess, does that conclude your presentation? It looks like we're at the end of the list here.
Yes, it does.
Okay. Any questions from members of the committee? Representative Bickford?
Thank you, Mr. Chair. Yeah, he's just aligning with current law. He's not making new laws in this presentation, and I don't want us to get it. We need to have a separate bill and a separate discussion about any further taxing of any streaming or anything else. That's why it was taken out of the budget, the supplemental. So.
Yeah, and I'm just getting at equalizing. I'm not talking about creating a new tax, just making sure that regardless of how someone orders a program or a movie, that it's taxed the same, you know?
Right, but he's just aligning with current law. He's not making new law here.
Yeah. Any further committee discussion or questions, Mr. Sagerson? Or I'm sorry, Mr. D'Alessandro? Julie? You're on mute, Julie.
There you go.
Okay, there I go. Sorry. Forgot I had muted myself. I'm going to do something that I do like maybe once every 10 or 15 years and propose a committee amendment. Remember back at the beginning when I mentioned the change that's proposed in the date regarding the education of reports from the Department of Education and Maine Revenue Services regarding the educational opportunity credit. As part of doing some of the research on that provision, I discovered a provision in Title 36 of which I am unaware, which is related to that, those reports. Those reports in current law are due to the Education Committee and the Tax Committee by March 1st of 2021. Neither agency has provided a report. And Mr. D'Alessandro explained to you that was because of extenuating circumstances, which has made it difficult, and which is why they're proposing to change that date till next year. So the date would come in on February of 2022. Connected with this structure, with the anticipated date of this year from those two departments, there is another provision in statute which requires the Taxation Committee to essentially review that information, review the educational opportunity credit, and by June 1st, 2021, issue a report as to whether the credit should be retained, repealed, or modified. My proposed amendment is, since they're changing the date of their reports to you, that you might want to consider changing the report by which you're required to review, the date by which you are required to review the report from 21 to 22. I didn't even know that was in there until I started researching some of this stuff. But it's a suggestion. It's your bill and your amendment.
Representative Bickford.
Thank you, Mr. Chair. I'm going to make a motion not to pass as amended with changing our reporting date to 22 instead of 21.
Second it.
And Mr. D'Alessandro's amendments, I assume, as well.
Yes, absolutely.
We have a motion to pass as amended using amendments suggested by Mr. D'Alessandro and changing the reporting date, seconded by Representative Kryzak. Any further committee discussion?
I just want to make sure that we're clarifying that the Better Betty assessments are that we're sticking with the 3 years and not making it infinite. Correct, Representative Bickford?
Yes, that's correct.
That's one of the suggestions from Mr. D'Alessandro. He said that they talked with MRS and agreed to 3 year.
Great.
Any further committee discussion? All those in favor, please signify. So that is unanimous of all members present.
Thank you.
All right, so that concludes the work session on LD 1216. And that's the last bill we've scheduled for work session for today. Do you have anything else for us, Julie?
No.
Okay. So I guess that concludes our work for today. So we will see everybody on tomorrow in session.
Actually, sorry, Senator Chipman, I just want to, we have a public hearing this afternoon at 1 o'clock.
Oh, I'm sorry. No, I'm sorry. That concludes our work session. Yeah, ahead of myself. Back at 1 o'clock for public hearings. Yes.
And use the same link.
Yeah, using the same link.
Could I get a show of hands of who will be here and if there's anyone that won't be here? Or just scream?
I can be here at the start, but I've actually got to go to transportation and have to present a bill there. So I won't be able to stay for the public hearings, but I'll be here to get started if we need a senator.
Okay.
I have a couple appointments this afternoon, but I might be able to get here to get it started.
Okay, terrific. All right, I will be driving. My niece will be driving me, so she doesn't know that she's going to be driving yet, but I'll be there since everybody's going to be in and out. Okay, great.
What time?
1 o'clock.
Thank you.
You'll be able to chair the public hearings, Representative Terry?
My fingers are crossed, but yes, I believe so.
Problem, I have to be over in transportation because I have to introduce a bill, or otherwise I'd stay to chair. But
okay.
All right, sounds good.
We'll make it work.
Yeah.
Want it 1